Estimados senhoras e senhores, é meu prazer e honra de fazer esta apresentação da parte da Comissão Europeia neste evento dedicado ao financiamento colaborativo. E, antes de mais, eu gostaria de, sinceramente, agradecer ao CMVM e ao Centro de Investigação de Direito Privado da Universidade de Lisboa por esta oportunidade único e muito importante. E como devido ao meu português não chegar ao nível suficiente para a audiência tão estimada, eu gostaria de continuar a minha apresentação em inglês. So my name is Ivan Kuznetsov, and I work in the Director General for Financial Services, Financial Stability and Capital Markets Union. So many of you might already be familiar with the results of our work. We design and prepare the legislation for the European Parliament and the Council of the European Union in the financial services and securities markets area. You might know MiFID, Markets in Financial Instruments Directive, Market Abuse Regulation, CRR, CRD, EFMD, Capital Market Abuse Regulation, Prospectus Regulation, and the list goes on and on and on. So today, I'm very pleased, I'm delighted to introduce our new baby, and the name of this baby is the Regulation on the European Crowdfunding Service Providers for Business. And as I can safely rely on the paternal sympathy from some of you, I can reassure you that the birth of this baby has not caused about sleep deprivation and anxiety. Rather, we are very excited about the opportunities that this regime, the European regime for crowdfunding, will bring about to the European businesses. Now, I would like to take a small step back and to introduce you in a few words the set of measures that were unveiled by the European Commission on the 8th of March together with the crowdfunding regulation. In addition to the crowdfunding regulation, the Commission has adopted the proposal on facilitation of the regime for covered bonds, the proposal for the facilitation of cross-border distribution of investment funds, the proposal for the law applicable to transferable claims, as well as the communication on the law applicable to transferable securities. And all this has been accompanied by two communications. It's a very worthwhile read, and I encourage you to go back once you're back to your desks and to read communication entitled Completing Capital Markets Union by 2019, Time to Accelerate the Delivery, and which has been accompanied by the FinTech Action Plan. In a couple of words, the new ways how firms and businesses interact with each other and with investors have created unprecedented opportunities. We will probably hear today a lot about the cryptography, race of the cloud, the cognitive computing known as artificial intelligence, and distributed ledger technologies. All these opportunities have presented new risks and new opportunities, and in the European Union, like never before, we need to have a possibility to address those opportunities and assess the risks in order to boost our financial sector and economy. Now, going back to our baby, I would like to ask to think about for a second, so the cause of the rise of crowdfunding as a sector. I personally believe, and this has been already mentioned in the introductory speech, that the reason for the rise of crowdfunding is indeed the over-reliance on expensive and often unavailable unsecured bank lending. And since 2018, we still struggle to reach the pre-crisis levels of lending to SMEs and innovative startups. The Commission has been monitoring the developments in the crowdfunding area for a few years now. Back in 2014, we have issued a Commission's communication, and we have conducted a very comprehensive study and issued in 2016 a Commission staff working document. And at that juncture of time, we have concluded, well, we don't have enough evidence to take policy action. However, we continued to look in very detail at the developments of crowdfunding. And what we have established is the emergence of the barriers between member states and the tendency for the crowdfunding platforms and investors to be very strongly skewed towards the national frontiers and at best regional frontiers. We were often told by the stakeholders, by the crowdfunding platforms, that in order to operate across border, they had to adjust their business models, they had to comply with divergent national laws, they had to seek legal advice, they had to comply with the national laws in the area of marketing communications as well as consumer protection. And this is where we decided to step in and to take legislative action. All right, we are now through the first slide, and I would invite you to relax, sit back, as within the next 5 hours I'm going to, well, it's 15 minutes, to walk you through the substantial requirements of the crowdfunding regulation. On scope, so what we define as a crowdfunding service, it's the matching of funding interests between the project owners and the investors made through the crowdfunding platform and through the facilitation of granting of loans. This is the so-called lending-based crowdfunding, and through the placing of without firm commitment of transferable securities issued by project owners and the reception and transmission of orders, the so-called investment-based crowdfunding. The regulation is only covering the crowdfunding offers with a consideration below 1 million euros. And this is almost 100% the case. I already anticipate this question. So why is this limit so seemingly low? And this has to do with the fact that just a few months ago, the co-legislators, the European Parliament and the Council, have agreed on the text of the prospectus regulation, and 1 million euros is a de minimis threshold above which normally the prospectus would be required. The donation and reward-based crowdfunding are excluded from the scope of this regulation, and this has to do with the fact that it's not a business lending. It's not a business lending, and the basically doesn't arise with the same information asymmetry, and this is why some of the existing EU legislation, such as in this field of the protection of consumers, already applies to the reward-based crowdfunding. The regulation also doesn't apply to the situations where the project owners qualify as consumers, and we don't address the crowdfunding where the which is addressed to the consumers lending for the consumption purposes. Again, the rationale here is very similar. This is not a business crowdfunding, and the scope is already covered by some of the existing EU legislation, for instance, the Consumer Credit Directive, Consumer Mortgage Directive, and so on. Very important two important points that I would like to make here, that the licenses are not cumulative with other European licenses such as UCITS, MiFID or FMD. In other words, if you are a European crowdfunding service provider which is authorized under this legal framework, you are not supposed to seek licenses or to seek authorization, for instance, under EFMD or MiFID license, and vice versa. If you are a MiFID firm, you shall not seek authorization or be authorized as a European crowdfunding service provider under this regulation. However, and I will walk you through this a bit further, this license can be cumulative with a PSD license as a payment service provider. Now, very, very important point, the interaction with national regimes. Please let me ex ante assure you that the European crowdfunding service regime is in no way designed to prevent, to limit, or to somehow make an obstacle to the existence of the national regimes. At this moment of time, we have some member states that have opted for the adoption of the bespoke national regimes, and this has been the case for Portugal. Some member states have exercised discretion for the adoption of national crowdfunding regimes within the ambit of either MiFID or FMD or PSD. Now, we are dealing with an alternative sort of opt-in. This is a possibility, it's not an obligation. So we look at the European crowdfunding services providers regime as an additional, we call it 29th regime, that can happily coexist in parallel to the national regimes, with the difference that the European crowdfunding services providers regime can be allowing such platforms to offer the services on a cross-border basis. One of the important features is that the authorization and the supervision are exercised by ESMA, the European Securities and Markets Authorities based in Paris, and not the national financial regulators, as it is the case with some of the legislation up to now. Now, how to get licensed and obtain authorizations? We feel that we have put in place a rather coherent, light touch regulation. You have to basically prepare some basic documents, your incorporation documents, information about your management, your plan of operations. You have to put together the business governance arrangements, control safeguards regarding the processing of data, some of the outsourcing arrangements that you may happen to have, and that's it. You submit the documentation. 20 business days within ESMA, within which ESMA has to assess whether the information received is complete or not. 2 months after the receipt of the complete package of documents, ESMA has to do one of two things: either to give a green light and to issue the authorization as European crowdfunding service provider, or to refuse authorization. Now, ESMA is charged with pretty common tasks for this regime, which is to exercise the powers of oversight and supervision. It's a plain vanilla set of competences and tasks. It will be able to organize general investigations, on-site inspections. It can seek documents, interview people. There will be an exchange of supervisory information with national authorities. And of course, ESMA will be also equipped with basic supervisory tools and impose sanctions for the breach of the regime. Now, the logical question, which I would of course expect, is, so what's the price tag? In other words, I guess that once I start talking about money, the microphone just decided to switch me off. So
it was my fault. So.
No, that's right. So what's the price tag? In other words, what would be the cost of compliance and what's the cost of the privilege to be authorized as European crowdfunding service provider? And this is where the regulation says that the supervisory fees that ESMA can impose have to cover costs of authorization and supervision, and they would have to be proportionate to the size of crowdfunding activities. On this note, I would like to say that we don't know the amount of those fees yet, because they would have to be set out in the Commission's Delegated Act adopted by the European Commission and under the scrutiny of the European Parliament and the Council. But the intention here is really to make a very attractive, very competitive regime. We want to promote this label and we want to make this regime a success. There is perhaps another thing that I should mention, that there is no requirement for the crowdfunding service providers to have any minimum capital requirements of any kind. We don't, and we decided intentionally not to introduce any credit default insurance or insurance of any kind for the European crowdfunding service providers. And the bonus is that once authorized and expanding, scaling up operations to additional member states, there is no requirement to have any physical presence in the territory of the member states where such crowdfunding services are being rendered. In the next few minutes, I would like to just walk us through, without a deep dive in, of the operational requirements of the crowdfunding service providers. Once again, this is supposed to be a very light touch, very proportionate and enabling regime to take into account the variety of business models. There is a general requirement to have a stable and effective establishment, and for the management to have a management which is effective and prudent, and to implement policies which are required by the law. We're talking about segregation of duties, conflicts of interest requirements, arrangements to deal with complaints handling, etc., etc. There is a requirement for the European crowdfunding service providers to also have effective and stable establishment, and to act honestly, fairly, and professionally, and in accordance with the best interest of clients or prospective clients. Very important point is that the European crowdfunding service providers are not allowed to hold clients' funds or to make payments unless they themselves seek authorization as payment service providers, or they operate through a third party that is a payment service provider under the PSD. Now, when the crowdfunding service provider doesn't have itself the license of a payment service provider, it must ensure that if it charges a third party to make any transfers to the project owners, that such transfers must be made through an AML compliant PSD provider. Once again, as you see, I'm going back to the topic of non-cumulative licenses. You cannot accumulate licenses in parallel with UCITS, EFMD and NIFID, but you can have a parallel system where you have the European license as a European crowdfunding service provider and a national PSD authorization. Very briefly about the conflicts of interest, we are looking at two sides, the internal and external. The basic rule here is that European crowdfunding service providers should not have any financial participation in the crowdfunding offers which are placed on its platforms, and there is also a requirement for that limits the participation of the major shareholders. We define it as 20% or management or employees or any persons related to such persons to participate in the projects that are placed on the crowdfunding platform. Now, the inducements, crowdfunding service providers are prohibited to accept any remuneration, any discount, and we define it very broadly, any financial or non-financial benefit for routing the customers, investors' orders to a particular crowdfunding order. There is also a disclosure duty. You have to have a comprehensive disclosure of any discretion if you exercise discretion with respect to clients' orders, as well as comprehensive disclosures of any fees, costs, and charges. Two final points before you fall asleep. The entry knowledge test. Before accepting the potential customer, potential investor and give access to the crowdfunding platform, it's the responsibility of the crowdfunding service provider to measure the ability of the investor to invest. And it's a set of basic questions assessing the investing experience. And in this note, the intention is really to understand whether the investor is capable or not to invest. And to the extent that the platform assesses that the investor doesn't have a sufficient investing experience or has already invested before in other multiple projects, it would have to decide whether or not the experience is sufficient. And if it's not sufficient, you require the platforms to give a risk warning. Another important point is sort of the form of suitability test, and it's basically the ability to simulate the bearing of loss. So if and we measure bearing of loss as 10% of the net worth. So if the investor is investing its capital, then if to the extent that this amounts are exceeding the 10% of the net worth of the investor, then it's again the responsibility of the crowdfunding service provider to issue a risk warning. The important principle, however, remains that the failure to have sufficient knowledge and the failure of the ability to bear loss, if you fail both tests, would still not prejudice and not limit the capacity of investor to invest. Once again, it's invest at your own risk and peril, and we want this regime not to prevent people from investing in those projects that the investors deem are suitable to them. Final point, as you know, in the European Union, we love acronyms. And here I want to give you yet another acronym, the so-called Key Investor Information Sheet, or KISS, which is probably resembling with the KID in the PRIPS. So this is a very short, up to 6 pages document with main disclosures. It has to be prepared by the project owner and addressed for each crowdfunding offer and be made available to the prospective investors and investors. And this is essentially enumeration, and we have some specific set of requirements. Please have a look at Annex 1 of the regulation. It's disclosures about the business model, about the main risks. We also require to indicate specifically in the case that you invest at your own risk and peril. The investment in this crowdfunding offer may bring about total, complete or partial loss of capital. So it's really up to you that this investment is possibly liquid, that it's not covered by the any comprehensive deposit guarantee scheme or any insurance of any kind. So that's the way we want to balance the risk appetite and the risk warnings and the protection of those people seeking riskier investments. Ladies and gentlemen, I would like to complete here. Of course, continuing for much longer would be what I see as an exciting exploration of this enabling regime. However, it would not make justice to the wealth of information we are yet to receive from our distinguished speakers. And I would like to thank you very much for your attention.